Good morning, everyone, and happy Data Privacy Day. I have to say, it is really a thrill to be doing this event for the third year in a row with the National Cybersecurity Alliance, and to see the amount of interest we have from all of you. I know we've got folks who are engineers, who are in media, product, and lawyers and policymakers. And it just goes to show what an important topic we are here to discuss today, and to take some time out from our busy work to really get an opportunity to learn from some of the leaders in the field and think about some of the hottest topics and issues in data privacy for 2020. So welcome to LinkedIn. We are excited to have you here. We are very excited to partner with the National Cybersecurity Alliance and to have the great work of Kelvin Coleman's team and everyone there who's helped us put this day together. And I just want to give a quick thank you as well to all of the Microsoft employees, the LinkedIn employees, and the GitHub employees who are joining us here today, both live and on the stream. I think it really speaks to the culture our companies have created in terms of making privacy something that every employee values and knows that matters. So thank you all for your participation. And with that, I would like to introduce our first speaker for the morning, Gregory Smolynec. He is the Deputy Commissioner of the Canada Office of the Privacy Commissioner, and he's going to give us a few words to start our morning off. Thank you, everyone.
Thank you very much. Good morning, everybody, or afternoon. What time is it now? Thank you very much for the invitation to help kick off Data Privacy Day here. There's a conversation around the world that's growing louder and louder right now, and that's on how to frame privacy. It's going on in Brussels. It's going on here in California, of course. It's also going on across the continents, in Asia, in Latin America, in Africa, in fact, around the world. And there's a big debate about privacy in Canada as well. It is a historic moment, and we're all part of it. Everybody is. Every citizen, consumers are part of it, entrepreneurs, scientists, legislators, regulators, and of course, privacy professionals as well. And that's because no one owns privacy. No one owns this issue. That's because it's a shared value across democracies, one that makes our cities livable, one that makes our cultures vibrant. It is, and I stress, instrumental to both liberty and democracy, and it's increasingly under threat. In fact, I go so far as to say that the absence of privacy defines authoritarianism. Now, I'm conscious that today's theme is a vision for the future, but I'm a historian by training, and I want to briefly historicize the moment that we're in right now. My first point is that privacy is a contested concept, and it's always been that way. Privacy and how to protect it's a very, very old debate. Formal arguments around public versus private life, claims of confidentiality for personal property, legal protections for the family home as a sanctuary, no-go zones for government. These debates go as far back as Cicero in Roman times, and even further back still. Roman law was rife with debate over what fell into the basket of state ownership and control, public, versus individual actions and exchanges considered offside for government direction, private life. Similar debates occurred in medieval times around how to circumscribe the authority of the state or crown and how to modulate demands of government on property holders in private affairs. This led to, among other things, innovations such as great charters, the Magna Carta. Absolute monarchy gives way to modern democratic governance, and we see this enshrined in our constitutions. The American Constitution and the Canadian Constitution provide for fundamental legal constraints on how state authorities can enter, seize, or search private property. All that to say is privacy is not any kind of new hang-up. And it's something that has been going on, these debates have been going on for millennia. And to say otherwise is basically to paper over these centuries and thousands of years of social and legal history. That having been said, in this long history of privacy, we have arrived at a particular moment. And I think it's not too much to say that it's a critical time. And now we see privacy increasingly being considered as an articulation of risk, very serious risk. It's an obvious thing to say that businesses and governments today are confronted with and are actually themselves accumulating ever larger data sets connected to ever broader networks and systems. And this has in fact created new risks for both state interests and for individuals. It's kind of commonsensical. As organizations compile and combine ever more elaborate and exhaustive repositories of personal information, this information is reasonably being considered to be of extreme value. A lot of people refer to it as a strategic asset. So it's obvious. It's also the case that this information is being targeted by various actors. We have snooping, theft, surveillance, hacking. Interstate information warfare is on the rise. We have increased risks of intrusion, theft, loss, abuse, and other consequences. Indeed, hostile state interference in democratic processes are all growing problems. And we can cite a litany of cases from the realm of data protection alone. Multinational tech conglomerates and globalized intelligence agencies, some of the most technically advanced and well-funded organizations in the world, have not been at all times able to foil persistent attackers, even to detect terabytes of information being pulled off their networks, at least not at all times. In Canada, for the last year now, we've had mandatory breach reporting to our office, the Office of the Privacy Commissioner. We've seen about 30 million Canadians affected by privacy breaches. That's almost the entire population of Canada. And breaches don't affect only commercial transactions or impact individuals in isolation. We've seen cases that have demonstrated that privacy violations affect democracy and the integrity of democratic processes. Now, these problems are significant in themselves, and they're contributing to a growing problem of trust around the world. Survey after survey confirms this. People's trust in institutions, including in democratic institutions, is falling dramatically. As we mark Data Privacy Day, I urge everyone to use this occasion to take stock of the risks to privacy, the attendant risks to democracy, and to strengthen privacy protections, because strong privacy protections build trust, trust in commerce, trust in the economy, trust in democracy, and even trust in the future. I have one last point to make, and that's around the idea of privacy as a human right, both looking backwards and forward. Modern privacy laws developed in large measure in response to concerns over personal reputations and private affairs. For 2 centuries now, in developed democracies, new technologies have always spurred debate about new legislation and regulation of privacy. A milestone came after the Second World War, after the horrors of the Second World War, after the Holocaust, and in the shadow of totalitarianism. Privacy was recognized as a human right in the United Nations Universal Declaration of Human Rights, and this set the stage for further privacy legislation. Article 12 in the Declaration, which deals with privacy, went on to provide a basis for the International Covenant on Civil and Political Rights, the European Convention for the Protection of Human Rights and Fundamental Freedoms, and these in turn underpin the current European Union legal regime for data protection, the GDPR. I think that this point about privacy, that it is a human right in and of itself, and that it is instrumental and essential to other rights and to liberty and democracy, needs to be fully understood and integrated. It needs to be integrated into our thinking, it needs to be integrated into our laws, and into our practices. Basically, we cannot have public democratic life without privacy. The scale of the problem demands a commensurate response. Privacy must be recognized in this way. Otherwise, we don't only put individuals at risk, and that is bad enough, but our democracies as well. And it's not hyperbole. We are witnesses to these developments day by day. Now, I don't want to end on a note of pessimism. In fact, I'm quite confident that people of good faith across the world will rise to the occasion and protect their own right to privacy, understand and protect the role of privacy in democratic society, and recognize and respect the rights of their fellow citizens. I hope you found these reflections thought-provoking and hopefully useful. Thanks again for the invitation, and I look forward to the rest of today's discussions.
Please welcome Kalinda Reyna and panelists for Privacy Across the Globe.
Give us just a moment to get everybody seated. I'm already worried about these chairs because I'm 4'11", and these are very high and look unstable. So I'm going to take my chances and ask that my panelists join me up here. All right. Yeah, they're unstable. Hopefully we look cool in these chairs. I'm gonna scoot out just a little so I can see all of you. All right, thank you guys for being patient with us while we get settled. So this panel is Privacy Across the Globe, and we are very fortunate to have 3 individuals join us who are experts in their field and also are from different parts of the globe and represent those different perspectives. So before I ask each of our panelists to introduce themselves, I just want to give you a sense of where we were thinking we would take this conversation and why we think this is such an important topic. As Gregory just said, privacy is something that needs to be thought of as a human right. And I think for many of us who've been in the privacy field for a long time, 20 years or more, it's taken a while to get a room of this size filled with people also interested in that topic. So we are making progress, I believe, in that. But at the same time, technology has greatly changed over the past 20 years so that the data we were worried about being exposed in the 80s and 90s is at a whole nother scale today and will continue to grow at a rate that many of us might find hard to imagine. So with that, global privacy laws and where this issue is headed is more important than ever. And as we're seeing over the past 5-6 years, I think first with the Snowden revelations, which really brought an awakening here in the US, and then Cambridge Analytica, which globally made people aware of just how much they were sharing and how little control in some cases we might have over our data, to the GDPR, which was passed in 2018. We've really seen an ushering in across the globe of data privacy interest and laws. So many of you may be aware that Brazil has its new law likely going into effect this summer. India has a privacy bill on the books. California, not that we consider ourselves our own country, but we have recently just passed a new privacy law here that went into effect in January. And what we're seeing is a lot of these laws following a model that we saw under GDPR. So that's something that we're going to discuss with the panelists today. So I'd like to start with Gregory, if you could introduce yourself and just a few thoughts on what you've seen the impact be in the past 2 years since GDPR has been passed in Canada.
Sure. My name is Gregory Smolynec, as you heard. I'm the Deputy Commissioner of Privacy for the Office of the Privacy Commissioner of Canada. So GDPR has definitely been influential. It's not the only model out there. We're studying bills, California legislation, bills that are being proposed around the world. In fact, there have been certainly dozens and well over 100 countries that have introduced privacy legislation in recent years. So we're looking at all of them, and it's definitely been influential. There are certain aspects about the GDPR that we're particularly interested in. Its rights basis, as you could tell from my talk, and also enforcement powers. And the prospects of it having influence in Canada are are fair. There's a new government in Canada as of this past fall. It's a minority government, so we don't know how long it'll last, but they are actively contemplating updating of our laws.
Great, thank you. And Jared, do you mind introducing yourself and sharing with us what you think some of the impact has been since 2018?
Sure. So my name is Jared Howe, and I'm an attorney with the Division of Privacy and Identity Protection at the Federal Trade Commission. And some of the impacts of GDPR, I think it certainly has raised the prominence and attention that companies and firms have been paying to privacy. I also think that in a large part, it's been a great push for firms to start implementing, at least with the larger firms, implementing accountability programs and conducting the types of privacy impact assessments that we've been calling for in our agency, so that companies are better able to evaluate how their information data collection practices are affecting consumers.
It's good to hear. João?
Yes, hi, good morning. Good afternoon, good evening to whoever is watching us, those here present. Yes, well, I'm, first of all, as a government official, I have to say that everything I say does not necessarily can be attributed to my employer, but it's those are my own personal ideas. And I just wanted to pick up on what both of you said about GDPR, is that it has been effective for 20 months now. We are waiting for the review that will come up in May. Which is a review that was already provided for in the legislation when it was passed, to see how it's been working, how it's been implemented. And I think that the most important idea is to see that it takes time to actually put all pieces in place, and to make the whole machine run smoothly. And it's just a process that is taking place, and so we are waiting for the result of the review, and we're also waiting for the effective application by the different data protection authorities of the EU member states, because this is not about one single supervisory authority, data protection authority. It's about over 27. As you know, for instance, in Germany, there is even more than one data protection authority. So it means that the system that the GDPR instituted, this cooperation mechanism and consistency, it's really important. But it has to, let's say, to consolidate, and it takes time for this mechanism to really work and run smoothly. And with just 20 months of implementation, I would say that we are still in the early process. Again, it is a process.
You know, that's an interesting recurring theme I've been hearing at some of the conferences I've been attending globally, is it's only been 20 months, so the expectation should not be that we would already have seen significant actions. But for many in the audience who may not be as familiar as to why it is taking so long, I think a lot of people thought May 25th was going to come and immediately we would see changes occurring. Can you give a little insight into what's happening in Europe and what might be causing some of that need for a little more time before significant actions can be taken?
Well, as I said, we have several data protection authorities. Those are national data protection authorities, and with very big differences in terms of human resources and, say, budgets of the different data protection authorities. You can have, for instance, the British ICO, which is quite big, and I know they are on the way out, but still, until Friday, they're still
out of the EU.
Out of the EU, exactly.
Not out of the game of privacy.
No,
Yes.
definitely not.
Yeah.
And the thing is, like the most famous stakeholder or supervisory authority that has to deal with a lot of cases is the Irish Data Protection Commissioner. And in fact, Helen Dixon, she has always said that she needs more resources, more staff. I think they have 120, and they say they really need a lot more because they just have like 15 or 20 investigations into big tech firms. And for a small country with a small data protection authority, it's a huge workload, and you really need to have the means to get to do a proper investigation. That's why people are saying, when are the first the first results, the first decisions of the investigations coming out. It was supposed to be late 2019, then we're saying early 2020. This is just to show that the GDPR is like a federal law, but it's decentralized in terms of how it is implemented. And again, you have all these data protection authorities in the different countries with different means, different resources, some of them with different opinions about very important issues. For instance, cookies. There are guidelines from the Spanish supervisory authority that are different from the guidelines of the French data supervisory authority. And this means that ultimately you will have to have a dialogue in the framework or under the umbrella of the European Data Protection Board, which is this overarching umbrella organization of all data protection authorities that will have to, let's say, give its opinion on what is the correct way of interpreting a certain provision. So that's why it is not something that you say everything is written in statute, so it's perfect. There are absolutely no room for interpretation. We just apply the law, and that's it. No, and in the US, we also know that it's not like that.
I was going to ask, so I think the message that I'm hearing from you is that there's difficulty in staffing. There's also difficulty in getting coordination across various countries to actually bring these actions into play. And so I'd like to hear from Gregory and Jared, from your perspectives, from both the US and Canadian perspective. What are you finding since GDPR went into play in terms of some of the challenges that João has emphasized in Europe? Are you finding those in your countries as well in terms of being able to help enforce rights for your citizens?
A big part of the discussion in Canada about new privacy law, is interoperability and interjurisdictional compatibility of the legislation. As many people probably are aware, European Union adequacy requirements also drive privacy discourses and legal reform in other countries as well, obviously in the US and in Canada. There's a curious thing that I hear from businesses. When asked, Canadian businesses that do business in Europe and are subject to GDPR compliance, when asked, how's it going? The response typically is, no problem, we're good. Then when we say, well, here's what we'd like to introduce in Canada, they go, oh, you can't do that. There's a problem with some of the features of GDPR being apparently introduced in Canada where there's no problem in complying to GDPR if they're doing business
So what are
in
you
Europe.
Interpreting that to really mean?
Well, I think there's probably a lot more that could be done in the Canadian context. That I think there's just a natural, I don't know if it's natural, but there's some kind of reluctance to regulation, which isn't unusual, and a kind of hesitancy. You probably see that across all kinds of spheres of regulation. But that's something I notice. GDPR, we got it, we're good. We figured it out how to operate in this environment, but don't bring any of that stuff here. But we'll have to. It's coming.
Do you think there are elements of GDPR that will be brought into Canada's approach to enforcing privacy?
Well, it's certainly part of our discussions. Canada faces a May 2020 adequacy review, European adequacy review. So this is something that's driving discussions. I think now this is very active discussion going on between us and the government. By the way, I'm not a government representative. I'm an agent of Parliament, which is independent from the government, which gives us some scope to talk about policy issues, which is different from a representative of a department or a ministry. I imagine that, put it this way, GDPR internationally has set a standard. In my mind, it sets, I think, a minimum standard. So countries around the world, there's the Convention 108 regime to which countries are signing up, which means that they're adhering to many of the features of European law or European ideas about privacy. So I think this is something that's, there's more and more convergence going on. And I take that to be, generally speaking, a good thing.
Yes, and I'm really curious to hear from you, Jared, from the U.S. perspective. We've seen states trying to pass privacy laws, as well as a lot of discussion around a potential federal privacy bill. What are you seeing at the FTC since GDPR went into effect? Has it brought any changes in the way you're thinking about enforcing privacy, and where do you think things are headed in the U.S.?
Well, so I think certainly there are a number of challenges that we have to consider when we're talking about a federal framework or privacy legislation. But I would like to acknowledge that all of our commissioners have come out in favor of broad-based technology-neutral privacy and data security legislation. I think what that means is that they've called for APA rulemaking authority for the agency, as well as civil penalty authority for civil penalty authority in the first instance. As for the specifics of what privacy legislation should look like, I think our agency has taken the position that really the high-level judgment calls should be made by Congress, with the FTC having the rulemaking authority to fill in the gaps. In terms of how GDPR has affected the United States and sort of the privacy regimes here, I mean, I guess I would probably say that first and foremost, the Federal Trade Commission is a civil law enforcement agency. So irrespective of GDPR or federal privacy legislation, we have been and will continue exercising our authority, present authority to protect consumers and consumer privacy in this space. I think that we can all agree that the FTC has been extremely active this past year. We've seen a number of blockbuster settlements. We have continued to exercise our 6B authority to examine industry practices and compel, for example, most recently, 9 internet service providers and their related entities to provide information about their data collection practices and how that affects consumers. We have come off a series of 15 hearings that we've held on consumer protection and competition in the 21st century. We held a privacy con last year, as well as a COPPA workshop, and are in the process of COPPA rule review. So we've been extremely busy and with extremely limited resources. And so I think we've been...
I'm hearing resources as a common theme, not only on the government side, but throughout privacy. So that's something that actually I would like to ask all of you how you deal with that challenge, because I think it's a never-ending challenge, quite honestly, to be able to staff up to the level that we all think might be necessary to truly do the work that your agencies or governments would like to be doing. How do you address that challenge?
So our office used to be complaint driven. Most of the work was on the investigation side of the house. About 2 years ago, what we've done is we've transformed our office to increase the role of promotion and the provision of advisory services, both for private industry and for the public sector. We also regulate our federal government in terms of privacy legislation, a separate act. And the idea is that you'll have greater impact if you provide better information about what it means to be compliant, how to be compliant, ideas for compliance, privacy by design, support, all these kind of things. You'll have greater impact. Most people in the private sector, of course, want to be compliant. They're seeking for solutions to their new initiatives. And if we can help them out in that, we'll have greater impact. So the idea there is a little bit of resource, properly communicated information, clear guidance, practical information for both businesses and consumers and government organizations will lead to greater privacy impact. Maybe it's not a complete answer, but it's part of the answer. On the other hand, given the pace of technological change, the privacy impacts, second order and third order effects that I talked about earlier, the implication of privacy for democracy and other things. This is a big space, and I think it does need to be resourced adequately. Our office cannot do everything we need to do, and that probably applies to corporations as well. But you know,
it does.
the
I'll speak on behalf of others in the room. Yes.
but maybe it's the cost of doing good business.
Yeah. So I hear from you, Gregory, you're saying you guys are playing more of an offensive role where you're trying to get in early and actually talk to companies and help them think through issues. João and Jared, are these techniques that you guys are applying in your offices as well?
Sure. So I should actually start off by saying the views expressed are purely my own as well. I always forget to say that. No
one here is speaking on behalf of the organization they represent. There you go.
But we really
except Gregory. All right.
No, we do apply a similar approach at the FTC. It's usually it's a three-pronged approach. I think obviously enforcement is certainly one of it's our bread and butter. It's our primary enforcement authority. But on top of enforcement, we also engage in policy work as well as consumer and business education. On the policy side, that really means that we hold workshops and convene stakeholders to understand what's going on in the industry and help provide guidance to firms as to what best practices for privacy and data security should be. On the education side, we have both consumer and business education. Consumer education is extremely important part of our mission. It helps consumers appreciate how their data is being collected and how they might protect their information. We certainly are active when there is a breach that occurs to help consumers know how to protect themselves or understand if they've been a victim of a breach. We have an identity theft portal that helps consumers navigate the process if they believe that they've been a victim of identity theft. And of course, we have business education and publish reports for firms as well.
So I'm hearing get in early, also try to educate the consumers. João, what are you guys doing in Europe?
Yeah, in Europe, so we have the European data protection, or rather, you have the national supervisory authorities, so the data protection authorities, with also the powers, advisory powers, the powers to send out warnings, so to have a dialogue with the controllers, with the companies. So it means that when everybody was crying, shouting about the fines of up to 4% of the global turnover, or to 20 million euros, whichever is greater. This is not, let's say, it's not the amount of the fine that defines the whole enforcement of the GDPR, because there is this back and forth, there is this dialogue between firms, companies, and the data protection authorities. And if you read the articles about the powers of the data protection authorities, of the several ones in the EU, soon to be 27 countries, they have this advisory power of having a dialogue, of sending also warnings, and not. When you look at the fines, this is really the ultimate, like the end of the road in a process. So it does not mean that immediately you will find this company without the rights of defense for this company. So it's really something that you have to see, that the dialogue is also very important. Also in the framework, this is about the powers of the supervisory authorities, of data protection authorities, and you have the European Data Protection Board, so the umbrella organization, having guidelines on specific issues of the GDPR. So far they've put out around 20 guidelines about specific areas of GDPR. Let's say the most controversial ones, or I would say the ones where there are some room for guidance, and where the companies and the data subjects asked for guidance. So yes, this is not all about fining and being the bad guy. It's really having a dialogue, because that's what companies need. You need to have like a situation where if you are well implementing the laws, and I think that is embedded into the GDPR as well.
Yeah. Gregory, did you have thoughts on that?
One quick comment. We're running hard, but we're not pacing technological change and the implications for privacy.
And my next question for you all was going to be, I think, related to that, in that for a lot of us who are on the business side, there are challenges that GDPR presents. I think it's a very broad law. It's open to interpretation, but there are some things that may, as technology changes quickly, become outdated, such as like the consent model. I'm curious from all of your perspective, from more of a regulatory side, what do you see as some of the potential weaknesses of enforcement for the GDPR or a framework like that?
So we know that consent doesn't always work. We're in our law reform work, we're exploring alternatives to consent as well. We're interested in European conceptions of legitimate interest, conceptions of public good. One thing that occurs to me, though, that I think would complicate our notion of public good is, and it's inspired by Zuboff's piece in the New York Times on the weekend, where she writes of privacy itself as a public good, which I think I was doing in my remarks as well, that we do have to consider the import of the various things that are in play in kind of a pluralistic way, not a relativistic way. Not every commercial interest is the equivalent of our society's democratic interests, for instance. We have to understand these things kind of deeply and, dare I say, philosophically, to be able to make evaluations. So consent's a huge thing, and there's a huge role in the future for meaningful consent. But what we have to do is understand different alternatives, different models, and see where they could be used without putting at risk the rights of people and the associated implications for liberty and democracy.
So are you saying we may need to weigh different pieces of information that are shared, or the context in which they're shared, differently when we're looking at what the framework might be for ensuring that there's some type of consent or some way of knowing whether people are okay with that?
So I think it helps sometimes to bring things down to earth and speak in terms of concrete cases, like what's the particular product, what's the particular initiative, how's that processing looking, can you get consent, is it feasible, looking at the alternatives, understanding. There's also a governance issue here too, right? Who decides what is in the public interest if you're talking about a commercial operation, right? On the public sector side, it's much easier. You have legislators and legislatures governed by democracy that make those decisions for, let's say, lawful investigation, police or intelligence services or whatever. Who adjudicates what's a legitimate interest or something that's in the public interest or the public good when you're talking about a commercial initiative is not something that we resolve. We're exploring all kinds of things. We're exploring data trusts. We're exploring different concepts. In fact, there's, I'd say, a lot of innovative thinking going on in the privacy world to figure out new approaches to how to better protect privacy, among other things, without having always to rely on consent.
Yeah. Jared, João, do you have thoughts on that?
Sure. So, I mentioned earlier that we had just rolled off a series of 15 consumer protection and competition hearings. And at our privacy hearing, among the stakeholders, notice and choice certainly played a prominent feature and part of that conversation. And what I think I heard from our panelists at that event was sort of agreement around this idea that this current notice and choice model can often lead to information overload and confusion for consumers, to be honest. I think that, that's to say that really, this model or practice of long-form privacy policies coupled with opt-outs can impose significant burdens on consumers to read those policies that may sometimes be too vague for them to fully understand or appreciate. I think we also heard from our panelists and commenters that we should be thinking about or concerned about practices such as the use of dark patterns to essentially exploit consumers or manipulate them into exercising type of choice that they might not necessarily otherwise have engaged in. Our panelists also mentioned this idea that there is fear and anxiety out there about from consumers about how their information's being used, and that can lead to chilling effects with respect to consumer conduct. And so I think that going forward, notice and choice really is going to be a significant challenge that we're going to have to address head on. What are the processes for us to provide upfront, meaningful consent choice mechanisms to consumers? How are firms going to be able to foster trust in a manner for them to continue innovating and providing benefits using consumer information?
I think many of us are struggling with how to make consent work on a mass scale when every piece of your life has actually got a piece of data attached to it, and it is happening on such a frequent basis. How does notice and consent work? How can you manage it? And as a parent of 3, I find it hard not to just manage it for myself, but for my children as well. So before we turn to you, João, for a reaction on that, I just want to let everybody know in the audience, if you have questions and of the panelists, please come up to the mic. There's a mic in the back. And I do want to open it up for questions after we hear back from João on his thoughts.
It's very brief because I think it's really important to have questions from the audience. It's just to say and to stress that the GDPR is based on processing of data using legal bases. So there's an article that says when you process data, it can be on the basis of consent, execution of a contract, legitimate interest, a public obligation provided for law or regulation. So it means that it's not all about consent. And of course, that's the companies, or say, of course, no. I would say that most companies, when GDPR became applicable, starting to play on the safe side and ask for consent when, in some instances, it was not strictly necessary to process data. It could be in the framework of the execution of a contract. And I guess that's the difference with the CCPA, because I think in California, there is not a list of legal basis for processing data. So again, the notice and choice is heavy, or it's really predominant still predominant in the US. So this is just to say that even if consent, yes, it's really important, but it is not the only legal basis for processing data under the GDPR. But fully understand that it's still a substantial part of the processing.
And I think it's an important point to make. It is not the only basis. I think the thing that is difficult with it, though, is it is the only basis that the end consumer sees and interacts with. So while on a business side, you can rely on these other bases, a lot of the public's not seeing that as much.
Just a really final remark. It's that in some cases when you have the cookies, it's not so much about the GDPR. It's another piece of EU legislation, sorry guys, which is called the e-privacy directive. So about the placing of cookies. And it's an obligation under that directive to ask for consent. And it's a directive that it's currently being reformed in the EU. But again, so it's not only about processing of data. It's really about placing of cookies in your equipment, and so it's broader. So this question of getting consent is broader than just about processing of data, which is strictly the area, the remit of the GDPR.
Good point. All right, I see that we have some questions from the audience. So would you step up and to the mic?
Thank you, Kalinda. My name is Lan Jensen. I'm the CEO of a nonprofit, Adaptable Security Corp. I also wear some other hats to help with the NIST DHS-led initiative for smart cities. And locally, I also am on the board of directors for the ISC Squared Silicon Valley chapter. So from my multiple hats, one question I want to raise for some insights from you, Kalinda, and your panel is that we know it's essential. Already it's mentioned it's human rights, privacy is. However, when we try to spread the word to the community, it's just so darn hard. I have to admit that I do not read all of the privacy statements myself. If it's a reputable company like Google, so I'm like, okay, darn it, some other people more capable or have time to do that will already have done it for me. So I skip through, right? Because otherwise, it's just unbearable burden for every single person to have to read through those statements. So my question is, do you think there possibly could be a way to make it simpler for ordinary people to consume and digest? Is there possibly a killer app for that? Right, so the statements could be, say, hey, I'm compliant to category A, I'm compliant to category B, and then people instantly know. They only need to know what category A stands for. So just a food for thought on that. And then my second point is a comment about the cultural differences playing a role in privacy as a human right as well. I know that in some parts of the world, it's unrelated to policies or politics, just the cultures could have different concepts for privacy. So my question on that is whether you think privacy could also be adapted to different cultures versus one big umbrella. Hey, everyone needs to come under this umbrella. Thank you. I'll take the
Thank you. So for your first question, I think it gets back to that discussion we were having around notice and consent. And we all know there have been attempts to try to simplify the notice process by having seals on sites, by the nutrition label concept. There have been multiple ways. Jared, I'm curious to hear from you specifically on from a U.S. perspective. What do you think the answer is to that issue?
Well, I think everyone is sort of right in that, notice and choice, and this came from our hearing as well, is that notice and choice by itself does pose significant burdens on consumers, and so it can't operate solely by itself. And so, there certainly is something to be said about accountability, corporate accountability programs and privacy impacts assessments, and as ways for firms to evaluate how their data collection practices are impacting consumers. So I think that's sort of one mechanism. Our agency has talked about just-in-time notices, and part of Section 5 is that material statements have to be clear and conspicuous. So there certainly are mechanisms out there. We have guidance on sort of how to effectuate notice, and so you can visit our website at business.ftc.gov if you would like more information on sort of our best practice guidance there. On the consumer side and sort of this idea of like information overload, I think that is sort of spot on. It really does put a lot of onus on consumers to be able to sort of appreciate and fully understand all these things. We do have guidance out there again for consumers to sort of streamline that process, and we sort of do our best to help educate folks on that.
Yeah, I think it's a challenging issue and one that many of us need to be thinking about solutions for more. On your comment on the human rights issue, João or Gregory, do either of you want to take that one?
Yeah, no, I'm just from the EU side. Of course, the right to privacy and right to protection of personal data is one of the rights enshrined in the European Charter for Fundamental Rights, and it is something that we really praise. And it's one of the aspects that, for instance, in the framework of Privacy Shield, which we're not going to tackle today, is being looked into really. So about how the protection of these two rights and the right to effective remedies is ensured and safeguarded in the US. So just to say that probably in the EU we are the ones most at ease with the human rights dimension of the right to privacy, private life, and personal data.
And given our timing, I was going to move on to the next. Do you have
Quick
something
comment.
to say? Yeah.
Diversity is both a fact and a value, but diversity is impossible without unity, and I believe in the universality of human dignity, which makes possible human diversity.
Very good answer. I like that. Next, yes?
So just following from that, so my name is Ashwin Krishnan. I run a small cybersecurity training company called Uber Knowledge, but I spent a bulk of my time as a podcast host. I've interviewed about a bunch of CISOs and chief privacy officers, but I'm not in the capacity of that. I'm asking as a uninformed California consumer. I have exercised my CCPA rights with 3 organizations, and all 3 sucked. User experience. In fact, right now I was going through one of the most popular gym clubs in the state. And as was essentially an email comes, I click that link, go to another website, I have to scroll through about 20 pages, and I get to the last page, and I see this column which says, they capture audiovisual information of the gym. For marketing purpose, they sell that information. They also, and this really got to me, is they make inferences based on my heartbeat, my weight, my height, and they sell that to third party. And please click on this if you want us to stop doing that. Click on that. 45 days later, I'll know whether I was approved or not. So my question to this esteemed panel is, yes, we're talking about GDPR, talking about CCPA. It's been authored by legal counsel and lawyers to protect the company. It is not consumer friendly. Again, going back to my esteemed colleague's comment over here, how do we solve that? We're sitting in this room, obviously there is a lot of audience over here who are trying to kind of do the right thing, but 3 organizations, and I still don't know where I stand. The 4th organization just spooks me. And knowing, I'm even wearing my tech hat, I had no freaking idea they're actually using AI and ML to actually predict and sell that information. So I'll stop there. Any comments?
Well, first of all, I hope I'm not a member of your gym. I'm concerned.
It's a very popular gym, so.
But I'll turn it over to the panelists. A reaction to that. That's a great question.
I can start out. I mean, so I can't comment on the specifics of your situation, but I think this really drives home the point that there is fear and anxiety among consumers about how their information is being collected and used. And we do need to do a better job and consider frameworks that are able to offer upfront, meaningful choices to consumers. And I think that we've sort of reached a stage where consumers have notice fatigue. They're being over permissioned. And so there has to be, when we're thinking about frameworks moving forward, there has to be mechanisms and safety valves for consumers on those aspects.
Gregory, did you want to comment?
Well, better laws in more jurisdictions is one thing, but there's frankly a political dimension to this as well. There's people can't be complacent about these things, and sounds like there has to be an associated call to civic and political action as well.
I don't want to answer the question directly because I realize I'm the moderator, not a panelist, but I will say that I think there is a responsibility amongst the general public to become aware of these issues and to take a stand when companies are reacting in that way with the way they're handling data. And I think the days of these very long notices where you would consent to everything and every right of everything you've given is handed over are changing. And I think the expectation is that more and more companies also begin to act on those issues more ethically and thoughtfully, but certainly you should quit your gym. Next question.
So this is somewhat related. My name is Mike Katz. So the U.S. is a signatory to the UN Declaration of Human Rights, and obviously Article 12 provides for right to privacy. what are the practical implications in the US of that right to privacy in an age of surveillance capitalism where I don't have control over my data? I don't own my data.
Anyone want to take that one?
Well, one of the things I've noticed is when I make a pitch like I did today, that to make sure that people integrate into their thinking, into their actions, privacy is a human right. Some will say, well, we can't do that. And I point out, well, it's in the UN Declaration. So I'm not actually debating it. It is a human right. The question is, how do you operationalize that? And it's a combination of all these things. It's a combination of the answers to the last question about what about my gym and what can I do? I mean, it necessitates a combined response from the individual citizen, consumer, regulator, government officials, legislators, corporate officers, et cetera. The absence of the recognition of a right does not trivialize that right. There are jurisdictions in which all kinds of human rights are violated in probably even more egregious ways than some of the things we're talking about. Doesn't mean that that right doesn't exist. The question is, how do you bring about the recognition and implementation of those rights? That's a super complex question. But I think we need to bring prominence, sunshine and light to the issue, recognize it as such. We're proposing that there are preambles and clauses in hopefully our future legislation that will include this rights basis, that will then bring about additional jurisprudence that recognize this. Don't forget that also, correct me if I'm wrong, but I'll speak of the Canadian context. Privacy is a quasi-constitutional right as well, right? There's the search and seizure implications as well. So just more prominence, more education, more recognition from everybody.
So I think we have time for one quick question. Yes?
Good morning. I'm Hiten Patel from Color Tokens, a cybersecurity product and also a compliance product company. I have a simple question. GDPR rules and regulations ask companies to have their customers opt in for managing and storing and selling privacy data. CCPA wants consumers to opt out, so by default they're opted in. Why did America decide to go this route, which is different from lots of other parts of the world? Most people are going for opt-in as opposed to opt-out.
I think you've highlighted a great conflict between the two and an important question. And we actually have a panel on CCPA coming up. So I would encourage you to ask that question there, because I think that would be really helpful to get some folks who are experts on CCPA to answer that. I am getting the signal we need to wrap. So I'm going to thank our esteemed panelists for a great discussion. And thank you also to the audience for being so involved with such good questions. Thanks, everyone.